Work everybody, Aaron Keller along with Brian Wagner, local criminal defense attorney, former prosecutor. We're getting ready to cover a couple of new cases coming up here on Law and Crime, and we've been talking about them just a little bit, forming a couple of preliminary opinions on them, if you will, Brian. So one is this William Woodward case out of Florida. This is a case where a defendant is basically charged with what sounds like a commando-style raid on his neighbors, and he killed two people and injured one, and there was a lot of bad blood back and forth between these folks.
Yeah, first, thank you for having me back. And we're going through right now, reading the order that denies the defendant's motion to dismiss. And the defendant's motion to dismiss was based on the stand your ground law. And what the judge lays out pretty well and pretty logically is that the stand your ground has a standard, and I'm going to refer back to it. The standard is that the circumstances that a defendant was in, and knowing what the defendant knows, would a reasonable person have acted in the same way, and that have been the only way to escape some sort of imminent death or fear of death. And the judge says, as an operation of law, that's not the case. Maybe facts at trial will prove otherwise, but as a matter of law, no.
Exactly. Now, it doesn't seem to me that this comes anywhere close to hitting the standard necessary for a stand your ground defense, because we've gone over this many times on Law and Crime. It's a subjective standard where basically we've got a defendant who it has to be viewed through sort of a 50,000-foot lens. From up in the sky looking down, people saying, look, is this reasonable? Was he under immediate threat? And that's the other key word. Is it reasonable from a big picture standard? And is it reasonable? And the judge found, as a matter of law, sort of leading into things, that no, though there was a lot of back and forth between these neighbors, it was a Hatfield-McCoy situation from the sounds of things, and it wasn't polite. Okay, it wasn't just neighborly joshing. I mean, there was some bad stuff going on between these folks, but it didn't immediately put this defendant in jeopardy. It's not like they were busting into his house. They didn't have guns aimed at him. He went over onto their property and just started executing them.
Yeah. So there's two things to keep in mind, and you've basically hit the nail on the head. Is there's one, whether or not a jury could find the facts persuasive, and then as an operation of law. And that's what the judge is saying here. The judge is saying, look, you might prevail at trial, Mr. Defendant, but I can't tell you, as a matter of law, 100% you are allowed to do what you had to do, and we're going to let a jury decide. And that's what this comes down to, is letting a jury decide whether or not he acted reasonably.
Exactly. And so we're going to be carrying this case for you folks watching at home. Starting tomorrow, that's the William Woodward case out of Florida. We've got another case we're paying attention to, and I think this one's just as interesting. This is the Jason King case out of California. This is a guy who was in the Marines, and he's out partying. He's out drinking. His friends have said, look, he was in no position to drive. Winds up getting on the highway, going the wrong way in the wrong lane. He's going northbound in a southbound lane. Gets into an accident, kills a couple of medical students. For the life of me, I can't figure out quite what I would do to defend him.
So with any DWI, there's two defenses. I wasn't driving, I wasn't drunk. He's going to have a hard time with both of those defenses.
Yeah, exactly. In other words, they lead to a conclusion of next to nothing.
Exactly. So based on everything we know, the defendant blew a .14. The legal limit in California is .08, so he's over and beyond the intoxication level. Now the question is, can he somehow say, I wasn't the driver? That's going to be hard to do. And so he has to attack really the amount that he was actually intoxicated and hope for a lesser conviction than the top count.
Yeah, and in this case, I think the interesting part is what they've charged him with. According to the jailhouse records, he's facing first-degree murder charges. Now, according to some of the other articles that I've read, they're second degree. So I'm trying to figure out if they tried to charge him with the top charge and then backed it down, or whether they initially charged him with second degree, hoping that he would plead to it and then threw the top charge at him. That I'm still trying to ferret out. But first-degree murder for a drunk driving case is pretty stiff.
It is, and there's a very different standard between vehicular homicide
and murder in the first degree. And what's going to be interesting is the California statute and how it actually breaks down murder in the first degree versus murder in the second degree, as opposed to something akin to vehicular homicide that we have here locally in New York. Now, vehicular homicide in New York requires 2 acts that are illegal in addition to driving intoxicated or above and beyond a 0.18 alcohol level. So that's going to be the interesting part about that Jason King case.
Yes, I'm curious to see exactly where they're going to go with that. Again, we've got a U.S. Marine on trial for first-degree murder, if I'm to believe the jailhouse records, because of this fatal car accident that happened on the highways in the San Diego area. That case also kicks off tomorrow. We're planning to cover both of these cases live here on the Law and Crime Network. We finally have live trials for you folks who have been sticking with us, waiting for 2018 to take traction. Look, you know, as a matter of due course, that rarely ever would a judge schedule a trial in the week right before the Christmas holiday, between Christmas and New Year's, and then leading out of it. That's the one time a year when courts generally shut down.
Yeah, I mean, judges and courts are human institutions. You have court officers, you have attorneys, you have jurors. No juror wants to be sitting on a jury the day after New Year's or the day before New Year's, the day after the holidays. And so it's just a human institution where, in reality, they take time off.
We've got a couple of other cases I wanted to talk about while we had the time here this afternoon, Brian. One is an update in case you've been following the case against the former Bachelor star Chris Soules. Well, we listened to an argument that his own attorney made. We carried that hearing live here on Law and Crime back in 2017 about whether or not this charge that he left the scene of a fatal car accident was actually going to stick. And one of the steps in the process was the defense arguing that the charge, leaving the scene, shouldn't stick in this situation because the law was unconstitutionally vague. Well, just as a threshold, what does unconstitutionally vague mean? We hear attorneys bring it up. You can probably explain it better than I can.
Unconstitutionally vague, as is often the case, the answer is within the question, right? Unconstitutionally vague. It doesn't give a good enough insight into what action is required by the defendant or the person of interest. Here, that argument lost, and the other part of that argument was that it required this person to remain at the scene of a fatal car accident and not just contact the authorities. And that was one of the arguments that the counsel for the convicted made. The problem is your constitutional rights are always infringed. That's not the question. The question is whether or not it's impermissibly and exceeding beyond the scope that it's prohibited.
Exactly. So going back and looking at the actual statute here, the statute in Iowa, which we've been over many times here on Law and Crime, basically requires people to stay at the scene except they can leave to seek necessary aid or report the accident to law enforcement officers. My plain read of it is that neither of those situations were involved here and therefore he had to stay, but the defense argument was basically the opposite, that once the accident was reported, which it was. We know that Chris Soules, the defendant, called 911. We know that he provided some first aid. We know that the first responders showed up. The argument that the defense made is that that was enough, that once the call was made, it was reported, that first aid was provided, and then once additional rescue responders showed up on the scene, he could take off. That was their argument.
So there's an expression: if you have the facts, argue the facts. If you have the law, argue the law. If you have neither, argue intent. That's what that attorney is doing. That attorney is arguing that the intent of the law is to make sure that you actually seek out help for the injured. But that's not what the law says. When you read it, it says, unless necessary for you, meaning the person that has the obligation, to report it to police, or necessary for you to receive medical treatment, you must remain at the scene. This person simply did not.
And that seems to be the way it is in most states, even though I saw some statement that said that this is some extreme minority approach. I didn't take it as a minority approach at all.
Yeah, every state, I'm sure, has different variations of the law, but in the end, the requirement is always the same. If there's a fatal accident, and you know it's a fatal accident, remain on scene. Remain there to inform the authorities what happened. You might not want to talk to them because you have your own self-incrimination rights, but you still have to remain there. There's no obligation that you actually speak to the police when they get there.
Yeah, so what do you make of what he ultimately did? He takes off right after, I think it was the paramedics show up, but before the police get on the scene. He takes off, he runs home. It takes police forever to get a warrant. Now, a lot of places, it's really easy to get a warrant. Police get them over the phone now. But apparently in this area in Iowa, it's either rural enough or the procedures just weren't in place for the police to get an immediate warrant to get him out and get a blood draw or something like that to figure out whether or not he was drunk, because ultimately that's what they wanted to figure out. So by the time they get a warrant to cross that sacred threshold into the home, they basically have nothing on him other than leaving the scene. That's all that they felt that they could charge him with. So if this charge doesn't stick, then he's off the hook, and you've got this poor farmer who was struck on his tractor and who died either there at the scene or very shortly thereafter, basically getting no justice.
And that's the state's best argument, is that this statute is designed to preserve evidence. And the evidence in this case that it was designed to preserve was that defendant's blood alcohol level. Because by him running away and leaving the scene, this is what the argument is. Whether or not it's true, we'll never know. But by him leaving the scene, the police and the prosecutors and the state were unable to find out what level of intoxication this person actually had. But by remaining at the scene, they can then quickly obtain a search warrant to take his blood, necessary, by force if necessary.
So what do you make of the defense argument that, hey, look, the Constitution provides us protections against unreasonable search and seizure and things like that, and this leaving the scene statute is not supposed to be designed to hold you captive so that the police can show up and basically take evidence from you, that's not what it's there for, that the intent of the statute isn't for police getting evidence, but rather to seek and make sure people get the aid necessary. I didn't think it was a great argument, but it was a skillful argument, I will say that.
So I would agree with you. It is a very nuanced, intelligent argument. The problem is the state search and seizure has to do with the state actor. Here, the state is not seizing your person. They're not requiring you to stay by actually physically restraining you. What they're saying is, if you are engaged in this act, you are required to remain there unless and until emergency personnel respond, meaning the police. And then, if you are free to leave, you are allowed to leave. So, in this case, had the police showed up and Mr. Souls was still there, and then the police got there and he said, look, am I under arrest? No, he could have left and he would have fulfilled his obligation. But he didn't stay, and that is the issue.
Exactly. And what else would he have done? He did what he did, and we had this argument. It flopped. I predicted that this would not be a winning argument for this procedural reason alone, not even getting to the merits of it, but just looking at the way the process usually grinds along. And I know that this wouldn't win me any points on a law school exam, but generally speaking, trial judges will kick a case down the line, they'll kick the can to the jury. And then this argument's preserved. If the appeals court wants to then rip the case up and kind of yank the rug up, the appeals court can dial it back and say, well, judge, you should have nipped it because this was a good argument, but the bottom line is it's at least going to get the case to a jury. Most trial judges are extremely hesitant to rule on a constitutional challenge to a statute because there's a presumption that statutes once passed are constitutional. And they rely on that. They basically take it and say, hey, look, this is the way it's written. We're going to have a jury look at it. Now, the jury could look and say that the statute's garbage and we think that he applied to the letter of the law here, or complied with the letter of the law, I should say. And then the appeals court can take this issue up again later. But again, going back to my original premise, it seemed to me that this was going to keep going because trial judges don't like to just stop cases dead in their tracks on constitutional grounds.
So two things. One, had they done that, then they'd be subject to the state's appeal. But also, a trial judge, just from a practicality standpoint, says let the jury either acquit or convict, just like you said. If they acquit, then I don't ever need to worry about being reversed on appeal.
This whole thing wouldn't even set any precedent. It would just be done.
Exactly. But if the jury comes back and convicts, then it's really not my place as a trial judge to decide the constitutionality of an argument or of a statute. Additionally, Juries are told whether they agree with the law or don't agree with the law, they have to apply the law as the judge instructs. So if a jury comes back and says, we think this law is unconstitutional, then they'd have an issue with that as well. So the only job for a jury is to decide the facts. The judge is going to have to decide the law. But you're right, most judges will not touch the constitutionality of a statute.
Yes, so if this case goes to the jury, which looks like it's where it's going to go, it sounds like we're going to hear a repeat of these same exact arguments in front of the jury. It's probably going to be very technically picking apart the letter of that leaving the scene law and trying to convince a jury that he somehow complied with it. Because the bottom line is we know that he left. You're going to have a million cops lining up to say, oh yeah, we knew he was in the house. We later found him at the house. We had to apply for a warrant to get him out of the house. The only hope he's got is that some juror is going to look and say, that sounds like he did what he was supposed to do, and if the legislature wants to make the law clearer, the legislature can pass a law that's clearer.
Well, and so that's what the summation by the defense attorney should be and probably will be, is, look, ladies and gentlemen, the people are accusing him, or the state's accusing him of violating this statute. They have to prove element A, B, C, D. They cannot prove that because here's what Mr. Soules did, and he actually complied with the law. So they're not going to make a constitutionality argument, but they're going to say that the people cannot prove each one of those necessary elements.
Yes, so this looks like it's going to go to a jury. Curious to see how it's going to play out because we already know that the state's going to argue the flip side. It seems to me that this case, as you pointed out, is going to hinge very closely on exactly how the judge instructs the jury as to the letter of the statute, because jurors don't get statutes to bring back. They usually get instructions, which are a little bit more, I don't want to say complex, but they're a little bit more fleshed out. They're a little longer. So this is going to be a case where the jury instructions, the arguments about the jury instructions are going to be critical. That's going to win or lose the case.
Yeah, and a good summation should always include telling the jury, this is what the judge is going to tell you. Let me tell you why we won or why we lost. And that is a really tailored, good summation, because then the jury can go back there and say, wait a minute, Mr. Wagner told me they didn't meet this element. You know what, Mr. Wagner's right, or Mr. Wagner's wrong.
Yes, this case will be grinding along. It's gotten a little bit of a delay here. Apparently it was scheduled for some action this week, but apparently it's getting pushed back a little bit further, so we will continue to monitor this particular case. Moving on to another topic now. This one's kind of interesting because it allows us to pick apart Twitter's user agreement. Twitter apparently decided right at the extreme tail end of last week that it would allow President Trump to remain tweeting. And this is interesting because a lot of people were calling for the president's Twitter to be shut down as a violation of Twitter's rules. Okay, so you've got a contract, a user agreement, and the user agreement references these rules. And a lot of people said, hey, wait a minute, he's using violent language, he's using language that some people would consider to be hateful. And that's a violation of the rules, and therefore he shouldn't be on Twitter. Now, this looks like a relatively thinly veiled attempt to silence the president from reaching a mass audience directly, but honestly, if he doesn't tweet, then he's probably going to put it on some official website. Does the vehicle really matter? But is it a violation of the rules of conduct? Twitter says no, it's not. I tend to agree with them. But it does raise questions about what's up with the rules of conduct on Twitter. You know, what's the process if people think that they've been violated? Do they enforce the rules with uniform application?
So it's interesting. Twitter has decided that there's a newsworthy exception to their rule in terms of the Twitter agreement. Now, that's not unique to Twitter. And so anyone that thinks that is unique to Twitter should keep in mind that libel, defamation, and other slander as well, there's a different rule when you are a news person or when you are a person in the public sphere. Whereas normally, for a libel case, you have to prove that it was false and you knew it was false. With a public figure, if you are sued for slander, you have to prove that it was made with material, malice?
Actual malice.
Actual malice.
In other words, reckless disregard for the truth.
Exactly. as a former anchor, you know that, or not a former anchor, as a current anchor, sorry. Right.
I believe I'm still employed.
Yes, you absolutely are. But so you understand that there is a difference in terms of newsworthy individuals and non-newsworthy and just lay people.
Well, that were to come if somebody were to sue the guy for defamation or something like that. But as to the actual agreement, because ultimately whether or not he stays on the service, from my read, is just a pure nature of contract law. Like, what does this contract require of everybody?
Except, one, the contract, Twitter gets to decide whether or not they want to enforce the contract, and they're electing to not enforce it against Donald Trump. Second, my point is that there's an analogy to be made. The analogy is that with Twitter has decided we are going to treat world leaders, because that's what they've said in their statement, differently than lay people. Now, where they draw that line, who's a world leader, who is a newsworthy individual, and who they're going to give leniency to, it's probably going to be arbitrary, but in the end, it's going to be up to Twitter to decide that on their own, whether or not they want to enforce their contract.
Yeah, I mean, it seems that they're, reading through the agreement, you can't infringe on trademark or copyright, you can't buy or sell Twitter accounts, you can't take somebody's name, you can't cyber squat on some famous name and then try to milk somebody for money by using the name. You can't use it for so-called unlawful reasons. But when it gets down into these sort of abusive behavior areas here, it says that you can't get into violence. You may not make specific threats of violence or wish for the serious physical harm, death, or disease of an individual or group of people. Okay, well, you've got the president tweeting about the possibility of nuclear war breaking out with North Korea. How does it fit into this violence rule? I mean, isn't that violence?
Again, there's the reality of the situation that certain people, and this is going to sound somewhat like, all pigs are equal except some pigs are more equal than others. Not everyone is given the same set of rules, especially if you are the president of the United States or you are a world leader. By definition, when the president goes or declares war, people are going to be killed. Now, normally under a layperson, that might be considered murder. It's not considered murder for any number of reasons, that there is a legal justification for it. Here, although we're not talking about a legal justification, Twitter has decided that they are willing to give a newsworthy or world leader exception because it is newsworthy.
Yes, and that's the crux here. I don't think that this is necessarily a new standard, and I haven't read every single Twitter user agreement that's ever been published, but if you go through the whole thing, there's this talk about violence, that's all prohibited in the user agreement. And again, I'm just looking at the contract that when you sign up to use Twitter, I'm on Twitter, I think you're on Twitter, we have basically opted in to be governed by this as a matter of contract law, same as anyone else sitting there watching. You've got this violence piece of this puzzle, okay, but you also have an abusive behavior subheading here. And I don't think that the president has violated the whole agreement because there hasn't been abusive behavior, because it specifically says if the behavior is newsworthy and in the public interest, the legitimate public interest. Well, presumably almost any policy declaration of a sitting president is in the legitimate public interest. We all have a legitimate reason to want to know what he's up to. So based on that, it seems to me that this is all fair and clean.
I agree with you. And on top of that, contract disputes have to do with standing. Who has standing to object to the contract? If you and I enter a contract to buy a house, you're the seller, I'm the buyer, and one of us varies or deviates from that contract, then we could sue each other to enforce that contract. Here, a third party, someone who's on Twitter, but is not President Trump and is not Twitter, has no right or standing to try to enforce that contract between the two parties. And Twitter has said, we're not going to enforce it, and obviously Donald Trump's not going to have Twitter enforce him being kicked off.
Yeah, exactly.
So,
now, let's say he wasn't a sitting president. Let's say he's a former president, something like that. Would the behavior still hit that newsworthy and legitimate public interest provision? There, I think an argument could be made that it wouldn't, because it would be someone whose opinion may be valid and worthy of public discussion, but if he said the same sort of stuff and he wasn't currently an office holder, I think there would be trouble under the letter of this agreement.
If George Bush or President Obama or President Clinton or Hillary Clinton or anyone you could think of that's political went on Twitter tomorrow and said, I think we should bomb the North Koreans and I think we should bomb every other country, would you find that interesting? Would that be newsworthy? Of course. Of course it would be newsworthy. Whether or not it would be a policy declaration, I think it wouldn't be, but it would still be newsworthy.
But you've got this key phrase here, newsworthy and in the legitimate public interest. If it's a former office holder, I think Twitter would be, now look, it would still be a close call. If Twitter had a jury, okay, I could see the jury splitting as to whether or not a former office holder could be somehow punished for something like this. But a current office holder, I think there's really not much of an argument to be made. I think that a current office holder can say whatever he or she wishes on Twitter, as this language is written here. But a former office holder, I think you're running into a little bit of a different area as to whether or not it's in the legitimate public interest. You know, if President Carter said we should bomb North Korea, is that of the essence right now? He doesn't have the power to decide. And by the way, I don't think President Carter would ever say that, but you know, that it really causes one to look at the letter of the language in this agreement.
Yeah, I don't think it's close at all. And the reason I say that is because, let's use presidents as an example, ex-presidents, they still are given every day a security briefing if they so desire. Now, their knowledge and their access to information is different than a lay person's, your and mine. So if they go on and say, based on what I know, that we should bomb whatever country, there is a although it's not a legitimate actual policy statement, it is legitimate in terms of newsworthiness. And I think, although I haven't read the contract in a couple of days, how it's formed or how it's stated, we're being a little too fine-toothed with it.
Yes, here's the thing. We all have to read these agreements. People just click on through them and don't pay much attention beyond there, but when it comes to a sticking point, you got to know what they say.
Yeah, and so let's assume that Twitter did kick off President Carter in the example you used. Then President Carter would be able to say, wait a minute, Twitter, you've violated the agreement that you and I entered into. But certainly as journalists, as a defense attorney, or as just a John Doe citizen, we would have no standing or ability to challenge Twitter's kicking off of the president or the ex-president.
It seems to me that this is pretty binding. But look, interesting little lesson in contract law when it comes to figuring out what's up on the Twitter user agreement. I actually enjoyed reading it because so many of us use this stuff. What's the standard for it? And it's actually not really that long to read. It's maybe 10 pages or something like that. And most of it is all boilerplate. It has to do with access to it. The actual rules are just a few paragraphs. Here's what you can do. Here's what you can't do. And of course, the next lesson is if you're operating a technology company, you have to have these kind of things in place.
And that's absolutely true. And the rules and how you enforce them can also be used against you or used for your arguments when you do get into these contract disputes. So it is not only important to know the rules, but to also know what their past practices in enforcing those rules are. So if this ended up being a civil lawsuit, that's the first thing you'd be asking in a deposition or interrogatories.
Part of me wonders if we're going to hit a point in technology where we have some sort of arbitration process for being kicked off of these extremely popular platforms for speech.
Well, there is already some sort of arbitration policies informed, and that's just general contract law, that the person that wrote the contract, it's construed most strictly against them, and often there's an arbitration clause that allows them or requires the contract to go to a binding arbitration to alleviate the cost and avoid going to court for a costly fight.
Well, let's move on here. We've been reviewing a previous trial that we covered here on the Law and Crime Network. This is the Jessica Chambers case out of Mississippi. The defendant there, Quentin Tellis, will face retrial coming up here in the new year, a couple of months out from today. This is a case that originally ended with a hung jury with a pretty even split. Almost half of the jurors agreeing with one verdict, almost half agreeing with another. Now, this is the case where a young woman was burned very severely in her car. She was doused with gasoline. The vehicle was set on fire, and she died a few hours later into the next morning at a burn unit in Memphis, Tennessee. We're reviewing the case while we wait for the next two trials we're covering here on Law and Crime to pick up those cases. The William Woodward case out of Florida, a situation where a neighbor went on a commando-like mission, shot his neighbors, killed 2 of them and injured 1. That case is in jury selection today as we speak. We're expecting opening statements tomorrow. We're also covering the Jason King case. That's the case of a U.S. Marine accused of driving while drunk, striking a car loaded down with medical students. 2 of them died. That case also in jury selection today. We're expecting testimony and opening statements tomorrow as well. But in the meantime, we'll dial back to the Jessica Chambers case, and we'll be back with some more analysis in a moment.